Hi, I'm Firearms Attorney Gilbert Ambler, and I am back today to talk about a very major update in Virginia's universal background check case and how the AG-elect, Jay Jones, is trying to throw his weight around in Virginia, even though he has not yet taken office, not yet sworn an oath of office, in fact, has no power just yet, and he's trying to influence the outcome of this case, not just by talking to people or trying to get involved on the fringes, but by directly filing things in the case to try to impact the end resolution of this case. We're going to talk about this today and what's going on. But as always, if you have not yet hit that subscribe button, what are you waiting for? Especially if you're a Virginian. We have both Virginia content, which is going to be very important heading into 2026, as well as national content. So give us a subscribe, a like, comment with your thoughts, share with your friends. That way both you and your friends can keep getting this important content. So what are we talking about? Well, this is a case that has been going on for years, and it involves Virginia's universal background check law that was passed back in 2020. That law was 18.2-308.2:5. And initially, when the trial court started looking at this, they initially enjoined the universal background checks with respect to 18 to 20-year-olds, because that 18 to 20-year-old age group could not purchase a handgun in Virginia after the background check law went into place. Why is that? Well, because they couldn't run the background checks. FFLs could not run the background checks on 18 to 20-year-olds for handguns, took away their ability to buy a handgun at all. And at the end of the day, in late October, the trial court finally issued a ruling striking down, this was a Lynchburg Circuit Court ruling, striking down the entirety of the law, saying due to that fatal flaw, due to the fact that 18 to 20-year-olds can't purchase handguns at all, and they have a right to arms in Virginia, due to that flaw, the entire law is invalid. I can't fix this law. The General Assembly messed it up too badly. The legislature messed it up too badly. Now, that was a late October decision. They had until December 1st to appeal that decision. And this is where things get interesting, because although Attorney General, who was a Republican Attorney General, Miyares, fought every step of the way before the trial court. And in fact, if you've watched my content, you know we don't necessarily think that Attorney General Miyares has been super friendly towards gun owners. I mean, this is a guy who right now, his administration is still actively defending and claiming that Virginia can ban firearms in rest stops. That's a whole separate case. But the point is that claiming that government-owned rest stops are sensitive locations. The point is he has not been terribly friendly to gun owners, and yet he had till December 1st to file an appeal. And keep in mind, he's only in office through early January. He may have given gun owners a parting gift on the way out by not filing that appeal. Here's where things get really interesting, though, because AG-elect Jones AG Texting Jones, as he's been called, decided that he was going to get involved, and on December 1st filed his own motion for an extension of the time frame in order to file an appeal, asking for an extension from December 1st to January 30th, which would give him the opportunity to take office as the Attorney General. He is scheduled to take office on January 17th, and then he could file an appeal. But this isn't really a valid motion for extension of time. He says that the motion for extension of time was necessary, but is that really the case? I don't think so. Really, I think this is a motion to intervene, because when you think about it, he is just a random outsider right now. Sure, come January 17th, he will be the Attorney General and represent the interests of the Commonwealth of Virginia. But as of right now, December 2nd, he is not representing the interests of Virginia. In fact, you need to look no further than the signature block on the motion for the extension of time. Is the signature block of the Virginia Attorney General, you ask? No, it is not. It is a private third-party law firm out of Washington, D.C., filing this on behalf of Jay Jones. I think this should be a quick and easy one for the trial court to answer. I think they should be able to say rapidly, sorry, Attorney General-elect Jones, you have no standing to intervene in this case right now. The trial court made a decision. That's up to the party currently representing the Commonwealth of Virginia, and that is Jason Miyares, and Attorney General Miyares. That is his decision on whether to appeal that. And I've spoken with attorney generals in the past that have articulated that they feel they've got a duty at least to challenge something when there's a constitutional challenge to a law that the General Assembly has passed. They feel they have a duty to defend it at least through the trial court level. And I understand why they feel that way. They feel it's their responsibility to defend any law. And I'm not saying I agree with them, but that's their feeling, that they feel they've got a duty to defend it at least through the trial court level. But then certainly if a trial court judge says, sorry, that law is unconstitutional, they don't have to defend it any further. And it appears that that is the decision that AG Mier has made, not to defend this universal background check any further, and in doing so, gave Virginia gun owners a gift on his way out of office, which of course Jay Jones is trying to mess up right now. So again, I don't know what the ultimate ruling is going to be here. To me, it certainly seems like a clear-cut issue where the Attorney General-elect has no authority. He is not representing Virginia. It's up to the current Attorney General to represent Virginia, and that Attorney General made a decision not to appeal, and to me, that's final. We'll see if the judge agrees with me. Nonetheless, all I can tell you right now is, legally speaking, things are getting very interesting, and we can already get a sense of what Attorney General Jones is going to bring to the table. Of course, this is all assuming, it's all speculative, right? We don't even know whether he's ultimately going to take office at the end of the day. I mean, he could decide to kill a bunch of women and children between now and then and be thrown in jail. We don't know that he's going to take office. So at the end of the day, I don't think he is standing. And then the things he's trying to argue other constitutional deficiencies that were not raised before the trial court and therefore are not appealable. He's also trying to argue that the injunction was unlawful under Trump v. Casa, which is the federal Supreme Court case where they said nationwide injunctions are unlawful for a federal district court judge to enjoin things outside of his district or outside of his circuit. He's arguing that that applies here. I don't see how a Virginia judge cannot enjoin the state police in all of Virginia. I think that is routinely done, and I think that is perfectly allowable. Interesting to see the Attorney General-elect Jones arguing that that cannot be done. Stay tuned. We'll keep you updated on how this plays out. Until next time.